With heavily disappointing receptions from Australia, Canada, Denmark, Netherlands, and exceedingly more, Prime Hydration LLC has fell off its initial high and now faces significant legal battles. Hello and welcome back to Brief Case Law, where we unpack the legal world one case at a time. Co-founded by internet personnel Logan Paul and KSI, this sport drink brand exploded with attention in 2022. We saw partnerships with major stars Kevin Durant, Mr. Beast, and Patrick Mahomes. People were drinking this everywhere. Kids were smuggling it into school. It was flying off of every store shelf. However, as we reached mid-2024, demand waned and people began questioning. August 2, 2023, Elizabeth Castillo filed a class action suit, which is a legal proceeding where one or more plaintiffs file a lawsuit on behalf of a larger group of people, the class, and it's popular for its benefits of spreading the cost of litigation and amplifying the voice of consumers, especially when facing powerful corporations. Elizabeth's case exemplifies this, seeking to hold Prime accountable on behalf of many consumers. She's alleging false advertising, breach of warranty, and violation of consumer protection laws. She found the presence of per- and polyfluoroalkyl substances, also known as PFAS, or forever chemicals, in Prime Hydration's grape flavor. This chemical has been linked to various health issues, including cancer and hormonal disruptions. The lawsuit claims that Prime failed to disclose this information, misleading consumers about the safety of their products. According to testing funded by the plaintiff, the grape flavor contains roughly 3 times the amount of PFAS allowed under FDA regulations for drinking water. The lawsuit seeks $5 million in damages. Such consumer protection laws are enforced by the Federal Trade Commission, ensuring companies are held accountable for misleading claims. Prime is attempting to have it dismissed on the grounds that the plaintiff did not demonstrate a recognizable injury or imminent threat. Furthermore, Prime Hydration says, and I quote, "the ubiquitous presence of PFAS in the environment, food, and other products," suggesting that information about PFAS is not exclusive to Prime. Paul backs this point up in a YouTube video saying,
"There's claims that PFOS or forever chemicals come from plastic. So in this case, they're not talking about the actual drink, the liquid Prime. They're talking about the bottle that Prime is manufactured in. This ain't a rinky-dink operation. We use the top bottle manufacturers in the United States."
The court has permitted Castillo to amend her lawsuit after finding some of the defense challenges sufficient and pleadings appropriate. They accepted her allegations as true but determined that the claims as currently written fail under the reasonable consumer test. This is a legal standard used to determine whether advertising or labeling is deceptive. It assesses whether an average person acting reasonably under the circumstances could be misled by the claims made in an advertisement or on a product label. This test focuses on the likelihood that a significant portion of the general consuming public or targeted consumers might be misled, rather than whether the plaintiff was misled. This test is typically conducted with legal reasoning, evidence, expert testimony, and case law. To better understand the gravity of these allegations, it's essential to recognize the legal consequences brands face when they breach contracts or engage in misleading advertising. Companies can incur hefty fines, reputational damage, and loss of consumer trust. For Logan Paul and KSI, consumer trust and reputation are core factors which can make or break their brand. Therefore, their actions of dismission and avoidance are understandable. However, when there is pressure from their audience, they may also release self-attesting videos like the one we heard previously. Now, moving on to the caffeine conundrum. April 8, 2024, Lara Vera filed a lawsuit asserting that Prime energy drinks contain higher caffeine levels than advertised, alleging that the drinks contain 200 mg of caffeine while independent testing revealed levels between 215 to 225, leading to accusations of deceptive marketing strategies. The lawsuit asserts violations of various state consumer fraud acts, New York deceptive practices and false advertising laws, breach of express warranty, unjust enrichment, and fraud. Vera argues that Prime's actions misled consumers and breached warranties regarding product safety and quality. She seeks $5 million in compensation and statutory damages, as well as injunctive relief to stop Prime's alleged misleading practices. The lawsuit is ongoing, with no reported settlements or closures as of February 2025. The Refresco legal battle. August 2, 2024. Prime Hydration LLC found itself stuck in yet another significant legal battle against Refresco Beverages US Inc., where they filed a lawsuit against them for over $68 million. The lawsuit claims several things. Prime breached a 3-year contract which required them to purchase a guaranteed volume of products. Refresco claims that Prime agreed to purchase a minimum of 18.5 million cases annually over the course of 3 years. In exchange, Refresco would invest in a custom product line built exclusively to serve Prime. The company says that Prime has failed to order the minimum required during the first year and hasn't ordered any supply from the new production line. They now seek $67.7 million in damages for the alleged breach. This amount includes take-or-pay penalties outlined in their contract, which is a clause that obligates the buyer to either take the specified quantity or pay a penalty for the shortfall. This is a typical clause which ensures the seller receives a minimum payment, compensating them for potential losses and reducing the risk associated with capital investments made to produce the goods. Refresco claims that Prime sales lessened considerably, which caused them to evade purchase obligations, accusing them of delaying negotiations and attempting to withdraw from their contractual obligations. As of now, neither Logan Paul nor KSI have been named as defendants in these lawsuits. However, Logan has addressed the situation indirectly on his podcast, Impulsive, where he discussed various topics including his business ventures and personal reflections, but sidestepped the legal troubles directly. Despite these legal challenges, Logan and KSI continue to maintain their public persona and engage with fans through his content channels. This case raises the broader question about the viability of influencer-driven brands. As seen with Prime Hydration, rapid growth fueled by social media can lead to equally rapid declines when public interest wanes. We see this in other influencers like Mr. Beast, whom upon releasing his Lunchly snack brand, ironically a collaboration with Paul and KSI, also faced negative backlash from the public, with criticism on the product's marketing strategy, target audience, and nutritional content. At the heart of these law cases, though, are critical consumer protection laws designed to keep brands accountable. These laws exist to ensure that companies provide accurate information about their products. The Federal Trade Commission have established clear guidelines which require influencers to disclose their relationship with brands. This allows more transparency for consumers. A failure to comply on the influencer's end may result in significant penalties for both the influencer and the brand. Consumers like you and me deserve to know what they're putting into the products which we put in our bodies. This isn't to say there aren't any influencer snack brands that are successful. The healthy sour strip candy Joyride, co-founded by famous YouTuber and entrepreneur Ryan Trahan, has yet to experience any reported lawsuits, but this could be attributed to their transparent marketing strategies and focus on using real ingredients which align with consumer preferences. Looking ahead, current trends show that consumers are more health conscious and more educated upon ingredient safety. We can expect to see more lawsuits related to misleading health claims. Brands which rely on influencer marketing must navigate these waters more carefully to avoid legal pitfalls. Though I doubt influencers will ever stop advertising products, one can only hope that they can promote one which holds ethical responsibility. And that's our case closed for this episode. Thank you for tuning in to Briefcase Law.